Court does call the case. Jeff Lewis versus Michelle Kresnak.
Daryl Barton appearing on behalf of Jeff and Julie Lewis.
Michelle Kresnak?
I am here.
All right. Okay, this is a termination of tenancy case. And basis for the termination?
They have violated the lease. They have not made any payments since February, and the outstanding balance is $9,851.15.
But there's a lease covering the premises.
That's correct. We'd like to ask to, if need be, leave to amend the complaint to include Noah Brush, who apparently has been living there the whole time, and is just the electricity was, he claims to be the main tenant. The electricity was cut off and added his name.
Well, we've got a problem here. And the problem relates to the notice to quit. Because the notice to quit is terminate the tenancy, but the claim that you have is basically a rent claim.
It's actually including in the lease. I asked that we had a supplemental judgment on that, but the lease, well, my glasses here.
I don't think that you can do that though.
Okay.
If the claim is for not paying rent, then one would have to file a non-payment of rent act.
It says under the lease, the lessee agrees that the lease that agrees that the lessee's failure or refusal to perform according to the terms of this lease agreement will allow the lessor's option to terminate this lease and begin eviction proceedings. That's specifically in the lease.
I don't doubt that, but it can't be terminated like that. There are two separate sort of avenues. One being a non-payment of rent, for others, non-payment of rent and termination of tenancy as a whole without the option to redeem. When it's a non-payment of rent, part of the remedial measures is that the tenant has the ability to redeem. And so I don't know that I can do much with this case because along the lines that you're asking me to terminate.
File a 7-day notice to quit.
That's what's going to have to end up happening. I don't think, based upon this, that the court has subject matter jurisdiction over the case for the reasons that you stated. So, and when that happens, the only remedy I have is to dismiss the case. So I'll dismiss this case for lack of subject matter jurisdiction, and then we'll await your arrival back here.
At first glance, this may seem like the landlord simply lost on a technicality, but the judge is actually enforcing one of the most important principles in civil procedure. Courts only have authority to act when the correct legal process has been followed. Here, the landlord attempted to pursue an eviction using a lease violation theory, even though the dispute was fundamentally about unpaid rent. Those are legally distinct avenues, and each requires different notices and different tenant rights. Judge Simpson is carefully protecting due process. In a non-payment case, tenants are often entitled to statutory opportunities to redeem the tenancy by paying what is owed before eviction proceeds. Bypassing that process could strip away protections created by law, which is exactly why the court refuses to move forward. Did you notice that the judge wasn't questioning whether money was owed? Instead, he focused entirely on whether the case had been filed under the proper legal framework. That's an important distinction. Winning the facts means very little if the procedure itself is defective. Expect experienced landlords to simply refile using the correct statutory notice rather than continuing with a case the court lacks authority to hear.
And with reference to that other issue, could you see Miss Weidling? We figured it out on the
other case.
The other thing talking about the execution.
Yeah.
Okay.
Is there something I need to see her about?
Pardon?
Is there something I need to see?
Yeah, if you talk to Ann, she'll update you on what we found out. Barnes and Barnes versus Contavious Scandrek.
Oh, speaking for the plaintiff, Your Honor.
And also Christopher Mayo.
Mr. Mayo made representations the last time that he was going to get us paid fully.
And has not.
He is not. And he's not here, and so I'm going to raise my right hand.
You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
Go ahead, sir.
We checked the ledger as recently as about 45 minutes ago, and the number is for rent is $2,335.34. That's 2335.34. $250 in costs for 258534.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
And if he pays it within the 10 days, I'll set it aside.
That is that. All right.
Thank you, Your Honor.
Thank you, sir. Ridgewood Apartments versus Amy Wisman.
Good afternoon, Your Honor. Mark Schlesinger appearing on behalf of plaintiff.
Hello.
Hello,
Your name?
Amy Weisner.
Okay. And how much is owing on this currently?
Judge, with court costs, there is presently $5,460.87.
And how are we going to get that taken care of?
I'm still waiting to hear back from SER. I talked with Hawk and they are out of funds right now, but they have me on their list. And I'm working with family to try to secure anything and still interviewing for jobs. I lost my job in December. I lost all my income source in December, right when I moved in. So.
All right. So the problem that we're going to have here is I've given the adjournment for the filing of at least a claim that you're seeking assistance.
Mhm.
I don't have anything. There's not a dispute at all as to what's owed. So what I'm going to do is I'm going to issue a judgment finding no tribal issue in your hearing. I'll issue a judgment for possession and money in the amount paid for $5,460.87. What I will do, since you're waiting on Hawk and I'm not sure where they are, the normal writ date would be the 23rd. I counsel over the objection of plaintiff. There's no writ until the 30th.
Yeah, the week
Judge,
ends
why-
on the 29th, so.
Judge, why would you assume I would have objected?
You're right. I didn't, but in case you did, I was taking a preemptive step.
Thank you, Your Honor.
Thank you. Thank you.
Judge, we'll
Thank you.
submit that.
All right.
Bye.
Bye-bye. Northfield Estates versus Tamara Coppin.
Good afternoon, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff.
Hello, your name?
Tamara Copens.
Tamara Coppins. I messed up the whole name, didn't I?
That's okay.
All right. What is plaintiff's claim today in this case?
Your Honor, let me
Oh, this is
verify.
actually her motion to set aside.
That's correct.
All right. And ma'am, what's your basis for setting aside the judgment?
I took a fall on their property and busted my kneecap in half. That was February 2nd, and I lost my job, a great job. I had just been approved. I worked for the Veterans Affairs, and I'm not quite sure I know what set aside means. I have tried to make payment arrangements with them. In fact, I even tried to make some payments, but I'm blocked to make them.
Well,
And
let me stop you there.
sure,
This is a motion to set aside the judgment which you filed.
okay,
And in order to, I'm not even sure how it got set for a hearing because escrow was not paid or bond wasn't paid on this, but that notwithstanding, there are two things that you have to show me. You have to show me that you have a meritorious defense to their claim for rent. And then the other thing that you have to show me is you have to have some good cause for your failure to appear back on May 23rd of 2025.
yes, I can.
Okay, so why?
I went to the courthouse, and it was closed in Saline. I'm on the summons, which I've never had before. It said appear to the court address above, and it said Zoom, but that box wasn't checked. I honestly thought that I would go to the courthouse, which I did do, and the judge would be on the screen. That's what I thought. But when I got there, it was shut down.
Yes.
And so then I panicked and I called, and the Northfield Estates told me, nope, you're evicted. And I'm like, what? And then I wrote a letter, and then the lady I was working with said, you got to fill this out. I filled that out. And I had no problem paying some money to an escrow. I didn't know about that. But basically, I've tried to make payment arrangements, but I feel strongly that they should work with me because this is on them. I mean, I didn't have to lose my job and fall. And So they should
Well,
work with,
ma'am, so let's assume I take that as your good cause. You're not disputing that you owe the amount.
I am disputing it in the sense that they should negotiate with me because I lost my job because of their
Negotiate.
mistake.
In what sense?
Negotiate that I don't have to pay the rent or pay some of it until I get back to work. And then the whole thing, because I literally fell on their property and lost everything.
I understand that, ma'am, but I don't know anything about that as to whether or not it's their fault. I
understand what you're saying, but I've given them all my medical records. They know. That's why I was surprised when I got the summons. Actually, my mom got it, and I'm glad I saw it because she doesn't have a great memory.
Ma'am, I don't know whether it's because of anything that the landlord did that caused the fall. And that would not be before me.
Okay.
So the real question is how are you going to get this judgment paid?
I've offered them to,
Because there's probably more owing now.
oh, I'm sure that there is.
And Your
How
Honor,
much is owing?
the total that's due at present, Your Honor, is $2,902.32. And Your Honor, if I could just state my position with respect to the motion itself.
Yes.
I don't believe that Ms. Copens has good cause for her failure to appear. She indicated that she went to the courthouse in Saline, which understand the courthouse is closed for renovations. But there's no indication that Ms. Copens then called the court to say, hey, I'm at the courthouse, it's closed, what do I do? Instead, she waited until later that afternoon to email me and say, hey, can we reschedule this? I had responded and said, unfortunately, no, judgment has already entered, so the court case is not going to be rescheduled. And so I don't believe that she's established good cause for her failure to appear. That's number one. Number two, I don't believe that Ms. Copens has established a meritorious defense to the underlying action. Your Honor, whether or not there was an incident on the property, and whether or not Ms. Copens can prove that my client was at fault for said incident, I am not conceding, Your Honor, in any way, shape, or form that they are. I would dispute any claims that they are. However, that is separate and distinct from any obligation that Ms. Copens has to pay rent, which she has not done.
This is where the legal issues become much clearer. The tenant understandably focuses on the injuries she says occurred on the property and how losing her job affected her finances. From a human perspective, those circumstances are compelling. Legally, however, Judge Simpson has to answer a much narrower question. A motion to set aside a default judgment requires two separate elements: good cause for missing the original hearing and a meritorious defense to the underlying rent claim. Even if the judge were willing to accept her courthouse confusion as good cause, she still must show a legal defense explaining why the rent was not owed. An unresolved personal injury claim does not automatically erase contractual rent obligations. Notice how the plaintiff's attorney reinforces this separation by acknowledging the allegation while refusing to concede liability. That's a deliberate litigation strategy. It prevents the eviction hearing from turning into a negligence trial about the fall. Would you have approached this differently if you were representing the tenant? Should the injury claim and the eviction dispute remain separate proceedings, or do you think the circumstances should influence the outcome? Those are difficult questions, but procedurally, the judge's path is becoming increasingly limited.
And so for those reasons, Your Honor, I would have to request that the court deny her motion and allow the judgment to stand in full force and effect. And at this point, we are well beyond the statutory 10 days that was entered on the original judgment, and would request permission for a plaintiff to submit an order of eviction in this matter.
I would like to respond if possible.
Go ahead.
I'm not an attorney. I lost my cell phone service because I have no money. And I have to go hook up to a McDonald's or something, and I'm using these silly text apps. I got in touch with, I didn't know who to call because the place was closed. And then when I would hook up, I figured it out and I made my calls to the court. I don't know if I emailed them first. And I have had no problem. And I've repeatedly said, do we have to go to court? Can I pay this amount and catch up every month? So it is as if they want my dad's house. My dad was a vet, and it's like they just want it. So I don't even know what meritorious means. I don't think there's any doubt in Northfield Estates but it's not for this court possibly, or it's clearly not, but I don't think they have any doubt of where I fell and why I fell. But I don't even care. I just busted my knee, never been in sports, never had that pain except for babies. And I lost a
Okay.
job at the NFPA.
Okay.
So
ma'am.
why can I not make a payment schedule, like $1,000?
Ma'am, that's gonna be something that has to be negotiated between the parties.
That's what I tried to do.
Okay, but if they don't agree to it, that means that you guys haven't come to an agreement on it.
Right, but they are now saying they want to evict me and my 83-year-old mom when the house has been in my family for 15, 20 years and it's been paid every month because I didn't prove that there was a good cause. I didn't go to
Ma'am,
court.
ma'am,
I'm
asking the
confused,
court to do something the court can't do.
which is what?
I can't force them to enter into a payment plan.
Okay,
All right. I am here right now on your motion and have to rule legally on your motion. And I told you at the very beginning, 2 things that you needed to show me: your good cause for your failure to appear, as well as a meritorious defense of the claim.
and both,
Frankly,
I've done one of those.
You have to show me both of those, and neither of those have you shown me.
I did,
We had gotten a call, and it sometimes does happen, and I'm not gonna dispute that somebody goes to the wrong courthouse. We get a call, we get something
you did,
that day
you did.
saying, ma'am, I don't have a record of that.
I
But
sent it to
even-
the court,
even if
and you
I
emailed me
did,
back.
Ma'am, don't overtalk.
Sorry.
I'll let you go on, I'll let you tell me anything, but you're gonna have to stop over talking.
Okay,
Even if you did, and even if I were to find that that's a reason for not appearing, I don't have a meritorious defense of the rent claim. I have to have both.
I don't have a lawyer. I wasn't told that, nor do I even know exactly what that means. So bottom line is they want $3,000, or what, how much does she want?
It would be 2902.18, but if you paid 2234.79, that may stop the eviction.
I'm very confused. I talked to this court. I spoke to this court. They emailed me back and said, Judge Simpson has set this aside. You're gonna go the 13th. So you're telling me to show you something
Ma'am,
that
told you that.
I have my phone, I have your emails, I have it from your courthouse. Not maybe
Your
not
Honor.
you directly.
Yes.
I can,
She's been copied.
I've seen the email chain, and there may be some confusion. The 14A4 civil clerk did send an email on June 2nd stating Judge Simpson has granted your motion to set aside default. The motion hearing is set or scheduled for 6/13/25 at 1 p.m. This will take place in person at the 14A1 District Court and provided the address. Have a great day. Ms. Copens forwarded that email to my firm on June 2nd. I then reached out to the 14A4 clerk and I said, the tenant forwarded our office the below correspondence. I asked for clarification as to whether or not the motion had been granted or if the court had simply granted a hearing on the motion. The civil clerk indicated judge has reviewed the motion and set it for a hearing on 6/13/25 at 1 p.m. And I said, so the motion is granted, is not granted, just set for a hearing. If so, that may need to be clarified with the tenant because I believe that Ms. Copens was under the belief that the judgment had been set aside, not that a motion had been granted or a motion hearing had been granted. I did correspond with Ms. Copens after that and explained to her that no, per my communications with the civil clerk, a motion hearing had been granted only, not that the judgment had been set aside, and that the hearing that was scheduled for today would be before Your Honor to determine if the judgment should be set aside or if the judgment would stand. Ms. Copens responded something along the lines of, I don't understand, I don't know the legalese. I'm going to take it to mean the judgment was set aside.
Ms. Dornbush, were you reading, did they indicate initially that the judgment had been set aside?
The email to Ms. Copens does say the judge has granted your motion and set a motion hearing. So it's a little ambiguous. Your Honor.
Got it.
The document that I believe was provided to Ms. Copens, and I'm looking for the notice to appear, it doesn't indicate hearing for non-payment of rent, it indicates motion hearing. And I'm looking for
Yes.
the attachment.
I'm
itself.
looking at it now, actually. I'm looking at our notice that would have gone out. All right. All right. So you're having the hearing at this point, ma'am. I have not ruled on it at this very moment. However, I'm telling you, I need two things. And the first thing being that there has to be a meritorious defense. Second thing being, and as I'll just tell you, neither one has been shown to me. So the motion to set aside the default is denied, the judgment will stand. And a writ may
So
issue.
you're saying that they can evict me?
Ma'am, what I'm saying is,
I honestly don't understand.
okay, then I'll tell you this. The judgment that was entered on May 23rd will stand. And in that judgment, if you read the judgment, you have a certain time in which to pay those funds. As I indicated, that amount was $2,234.79.
Okay,
If that is not paid, then the landlord can seek their remedy, which would be an order of eviction, indicating that nothing has been paid on this, and then have you removed from the premises. Yes.
okay, I have one more question. You were not going retrospective back that I had to pay it by the 23rd of that month. I can pay it today. Is that correct?
Do you have it today?
I can't, I will get it. I've got family and friends. I just wasn't gonna give
If you
1,000.
get it paid, they would need to, the way this court has ruled, they would need to accept it. So
Is there
if
an
it gets-
appeal? Because
Pardon?
is there a way to appeal? And I'm saying that only because I was sent something.
Ma'am,
that we're having a-
ma'am, I cannot give you legal advice. If you want to get legal advice on your rights,
I would like
appeal,
to do that.
then you can go and do that. But my order that your motion is denied stands. Motion denied. Thank you.
Well, I guess, you're very welcome. All right,
Court calls the case of River Ridge versus Kaylee Hamill Little. Hello,
Hi,
what's your name?
Kaylee Hamill. It's no longer Hamill Little.
Divorce?
Yes, thankfully.
Don't smile. No,
It's a
just
good-
don't smile. Okay, fine. All right. Okay, what is the claim at this point in this case?
No, Your Honor, $1,748.
All right. And how are you intending on getting that paid?
So I have a couple questions because there were court fees from the last time that were added on after every payment was made. Like we were here March, I think it was,
Okay.
and everything was paid up. And then they added court fees on the following month and then denied a payment. It was really weird. So I'd called, spoke with management about it. There's no longer a manager at that location, so they had to call who's ever overseeing it. And then it took days to get back. So I was very confused. And when they explained it to me, it didn't exactly make sense. So my ledger didn't add up and I'd already paid April's rent. So that ended up showing up late. It was a whole fiasco. And all in that time, I lost my job because of nursing school. So I've been fighting with unemployment.
Got it.
So I literally just had like a court hearing judgment, something along those, I don't know the technical term, yesterday that was canceled because my old job
All right.
stopped protest. I'm not sure.
So are you telling me you can't pay this amount? I'm sorry, Miss Dornbush, you were going to say something.
Your Honor, yes. At the last court date, Ms. Hamill did raise these issues and Judge Barr advised her to either call management or to call me to discuss. I don't know if she spoke with management or if her conversation with management took place that she referenced took place before or after the last court date. Your Honor, I can tell you that my client has credited court costs of $174 that were assessed in April. I believe my client's intention was to file suit in April. It looks like they did not. So they have credited those court costs. Ms. Hamill is, though, responsible for the court costs associated with this filing that occurred in May. So the
Got it.
$1,747 does take into account that $174 credit.
Yes, and that makes sense because the total figure given at the June 6th hearing was 1922. So
Okay,
they credited it.
okay. So I can make a payment coming up Friday of 300. But like I said, I'm waiting on unemployment. I don't,
When do you think your unemployment's gonna hit and then they're gonna have a retro check to you? You don't know.
you're more acquainted with the state of Michigan than I am when it comes to that.
Probably not, but
I also am
go ahead.
in the process of the hiring at another hospital that is working with school schedules. So,
All right. Here's what I'm gonna do. There's not a tribal issue. I'm gonna grant a judgment after a hearing on this matter for that amount of the 1748. What I will do, because they can't wait on that, so you can pay the 300 to them. That's at least gonna reduce your balance,
Mhm.
okay? And then if you get your unemployment in any retro, then you'll be able to do that.
yes.
I will have a writ to issue. It would normally issue on the 23rd over the objection of plaintiff if she's waiting on unemployment and I get it. I will go to the 30th. I'll give her an additional week because if she gets her unemployment, then it's going to be getting them to send that other check.
Right.
You get that. So, all right.
Okay.
That's over plaintiff's objection. But
Thank you.
Okay.
Your Honor.
So I have until the 30th.
you have until the 30th,
Perfect.
but get the 300
300
into
next
right
week,
away.
right.
Okay. But that gives you a little bit of relief.
Okay.
All right. Thank
Yep.
you. Scio Farms versus Derek Wanson. Wanshan. And Elizabeth Wanshan. Hello.
Hi.
What's your name?
Elizabeth Watson.
Wanson. Okay. And what is plaintiff's claim in this case? This is also a, yes, go ahead.
2905 and 46 cents.
90546. All right. And ma'am, how are you intending on getting that paid?
I wanted to ask today if we could pay this full balance at the end of the month, the 27th.
Will you have it by the 27th?
Yes.
All right. So here's what I'll do. No tribal issue after a hearing. I'm going to grant a judgment for possession. Okay.
Okay.
In that 290546. You say you'll have it the 27th?
Yeah.
Normal writ date will be the 23rd. I'll indicate no writ till the 27th.
Okay.
That'll give you time to get it paid.
All right.
All right?
Thank
Thank
you.
you. Spice Tree Apartments versus Samuel Bishop. Samuel Bishop, there is no response. You had previously been sworn. You may proceed.
Thank you, Your Honor. There's rent to retain of $3,584.74, cost of $169 for a total due of $3,753.74. We're asking for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Spice Tree Apartments versus Stephen Shelton.
Yes, I'm here.
Your name, sir?
Stephen Shelton.
All right, you got him. All right. That's not a phone, is it? I'll need a camera if you can get that. But what is plaintiff's claim?
Rent to retain, I'm sorry, Your Honor, the total with court costs is $2,921.69.
All right. Mr. Shelton, how are you intending on getting that paid?
I'm making a payment later today, and then I'm gonna pay the rest next Friday. So by next Friday, it should be all paid.
So by the 20th?
Yes, correct.
All right. So here's what I'm going to do. I'm going to find no tribal issue after hearing. I'll grant a judgment for possession in the full amount of $29,2169. And that is to be paid by the 23rd, that Monday after that. Okay. So that's your statutory period, but if you get it paid by the 20th, you'll be good. Okay.
Okay, sounds good. Thank you.
Thank you.
All right.
Valley Ranch versus Brandon Kuchar.
Brandon Kutcher, hi.
All right. Hello. All right. What is plaintiff's claim?
With costs, Your Honor, $4,676.45.
I'm sorry. Give me that number again.
4676.45 cents.
45. All right, sir. How are you intending on getting that paid?
We were trying to get it paid by Wednesday, 2 days ago. We were unable, but we'll be able to make payment in full through the rent payment portal online this weekend. We want to get it paid before Monday. I think then that adds another $100 on Monday. So we'll submit it before Sunday evening.
In any event, you'll have it paid before the 23rd, correct?
Yeah, absolutely. If you have to issue the judgment and then that can be set aside, that's fine. We've had to go through this before. We will have it paid in full before the 23rd.
All right, judgment to the, I'm gonna find no tribal issue after a hearing. There's no dispute as to the amount. Granted judgment for possession with a writ date of the 23rd. And then get it paid, you'll be all set and you can negotiate to set aside. All right? Okay.
Thank you
sir.
very much, Ms. Dornbush.
All right. And I think, is that it for you, Ms. Dornbush?
It is indeed, Your Honor.
All right, you have a great weekend.
Thank you, you too.
All right.
Bye-bye.
Arbor Club versus Sadie, is it Kayo Ampafon?
Sade Caillou Ashampong. How are you today?
I'm doing well. How are you?
I'm well today.
All right. And Mr. Katz, what is plaintiff's claim in this case?
Good afternoon, Your Honor. Sidney Katz on behalf of plaintiff. There's currently a balance due, including costs totaling $2,994, 2994.
Ma'am, how are you intending on getting that?
I'm currently waiting for a check to clear, so Monday or Tuesday, whenever that check is cleared, and it'll be paid in full.
It'll be paid in full.
Mhm.
So certainly by the 20th, you'll have it paid in full.
Most definitely, yes.
All right. I can do it one of two ways. I can grant you the judgment at this point, counsel, or I can turn it out to the 27th. Which would you prefer?
You know what, Your Honor? I'd rather not have to come back if we don't have to. Usually I'd say I'm just getting killed with these court dates, Your Honor.
I hear you. Me too.
So if we could just do a judgment and
all right,
you know.
And then if it's paid, would you agree to set it aside for her?
If she requests a set aside and lets me know, I will do it.
Okay.
Yes.
We'll do it that way. Finding no tribal issue after a hearing, judgment to the plaintiff in the amount requested of the $29.94 even. All right.
Great. Thank you so much.
Writ date the 23rd. So get that paid and then you'll be all set.
Yes, thank you.
Thank you.
Thank you, Your Honor.
Court calls the case of Six Trails versus Jordan Oren.
Good afternoon again, Your Honor. Sidney Katz on behalf of plaintiff.
That was nice of you to say close enough, but butchering names all day. Your name?
Jordan Oren.
All right. Well, I said it kind of close.
Yeah, it's close.
All right. All right. What is plaintiff's claim in this case?
Balance including costs totals 3,117. 3,000.
All right, sir. How are you going to get that paid?
So my dad is willing to help with a significant portion, and I actually just started work again at the start of this month. So I will get paid on the 26th of June, and mixed with what my dad is willing to help with, it should be able to cover the full costs by the
27th, 27th, Your Honor,
26th.
just to give him a little cushion.
Sure.
All right. So no tribal issue after a hearing. I'll grant a judgment to the plaintiff in the total amount of the 3117 and writ date 27th. All right, June 27th. All right.
Okay, sounds good. Thank you, Your Honor.
Thank you. Court calls the case Willow Ridge Apartments versus Angela Schmidt.
Good afternoon again, Your Honor. Sidney Katz on behalf of plaintiff. I think there she is. She's on Zoom.
There she is. Ms. Schmidt.
Hello.
Hello. All right. What is the plaintiff's claim?
Balance including costs, 4,311, $4,311.
Ms. Schmidt, when are you going to get that paid?
I was supposed to make a payment by today for $1,000. I tried to go online to make that payment and it wouldn't let me. So I was going to drop it off at the front office, but I wanted to make sure that that was where I should drop it off at prior to me doing so. So I have the $1,000. I'm just waiting to find out what my step is supposed to be. And then the remaining balance by the end of the month.
No, 27th. That'll take it pretty much till the 30th at that point.
Yeah.
27th is fine.
All right. A grant judgment to the plaintiff finding no tribal issue after a hearing for the amount of the 4,311 and writ the 27th.
All right.
All right.
And then
thank you. Yes, ma'am.
The $1,000, do I just drop it off at the front office then, since I can't do it online? It won't let me do it online?
However you pay it, you just have to pay the full amount by the 27th. There's no requirements of any specific amounts by any date. As long as you pay the full amount by the 27th, you're good.
Yeah, no, she's trying to figure out where she takes it because I think the portal's probably shut off for her.
Yeah,
but you may
the
not
portal's
know.
shut off. You probably have to find out when the office is open and drop it off there. Give them a call, just make sure. Okay.
Okay. And
Yeah,
I'm
thank
sorry,
you,
can I
ma'am.
have the total one more time?
4311, $4,311.
Okay. All right. Thank you so
Alrighty.
much.
Thank
Have a
you.
good
Thank
weekend,
you.
guys.
Have a good weekend.
Thank you.
Willow Ridge Apartments versus Woods Edward.
Edward here, sir.
Is it Edward Woods?
Edward Woods, yes.
Okay, I don't know.
I don't know. We keep on doing it this way, Your Honor. I have no idea. This is the only one. It's like the third time I've seen this.
Yeah, that's what's on the documents
I
too.
know.
Okay.
It's coming from
Edward
us.
Woods. Okay.
Your Honor, we did submit a proposed consent judgment to the court last week.
Yes. All right. And Mr. Woods,
I'm here, sir.
you signed the consent judgment indicating that you're going to pay a total amount of $5,030.
Yes,
Is that
sir.
correct?
Yes.
By the 27th. Do you have
Yes.
any other questions regarding anything on the judgment?
No, sir.
All right. Then I will enter that judgment. Sir, I do have to advise you have 3 business days to think about this judgment. If you believe that there's some legal reason, some confusion on your part, or some right you didn't assert, you'd have to file a motion with the court within that time frame. Doesn't mean that I would grant it, but you'd have that time to think about that judgment. You understand that, sir?
Yes, sir.
All righty. Thank you.
Thank you.
Thank you, Your Honor. Have a good weekend. Your Honor, I was
All
ready.
right. You do the same, sir.
I was ready for that last woman at the 1 o'clock docket or the 12 o'clock docket. I think you need like an MC to call your next cases. It sounded like you were one of the TV judges. Next on Judge Simpson.
You might be right.
Have a good day.
All right. Thank you, sir. Cheryl Barksdale versus Leo Stringa.
Good morning, or good afternoon.
Good afternoon. Who do I have here?
I'm Cheryl Barksdale, my husband Marlon Barksdale.
You just brought him along. He just straggling. All right. This is a termination of tenancy case. I don't have the defendant here. The defendant in custody. All right. There's no requirement that we bring them up. All right. Got it. And you were before Judge Barr. He disclosed that he had previously represented you, I think, on something. It doesn't matter. All right. And this is a termination of tenancy and there was a month-to-month lease. Is that correct?
No, it's a year lease.
Wow. Okay.
Lease violation.
Let's see. And in the notice, what are you claiming is the lease violation?
So in his lease, there is, in section R, harassment, annoyance, and, of tenants. So I'm getting complaints every week about him.
Gotcha.
And then also, in the lease
I'm gonna have to stop you, okay? I'm looking at your notice to quit. Everything else looks like it was done correctly. The notice to quit, however, was not done correctly. That's what gives the court jurisdiction to issue a judgment for you. All right. And I can tell you specifically what's an error on it. And that is that, I don't know, do you have a copy of your notice to quit in front of you?
I have the summons and,
You go back, because you filed the notice to quit, right?
Yes.
Well, anyway, at the very top, it says that your landlord is seeking to recover possession of property pursuant to, and then there are 2 check boxes. You have to put information as to why you're terminating it. So the second checkbox, which is the other, would be what you'd be describing to me. But, and I usually don't go through this with people, but you have to do that because they have to have a notice as to why you're doing it.
Okay.
Follow me? Okay. And so since you haven't, I hate doing this, but since you haven't filed a proper notice, I don't have jurisdiction to do anything except dismiss the case. Okay. So that's what I'll do, right? Because I lack subject matter jurisdiction, and I will dismiss this case. All right. Hold on one second. All right. And And that's the last case today. Yes. All right. Thank you, Amy.
Thank you, Your Honor.
Looking back across today's docket, a consistent pattern emerges in Judge Simpson's courtroom. The outcome of these hearings was rarely determined by emotion alone. Instead, each decision turned on whether the legal requirements had been satisfied. Some tenants received additional time because they presented realistic payment plans, communicated honestly, or demonstrated ongoing efforts to resolve their balances. Others were unsuccessful because the court simply lacked the legal authority to grant the relief they requested. One of the biggest lessons from today's proceedings is that hardship and legal defenses are not always the same thing. Financial struggles, job loss, illness, or personal setbacks may explain why rent went unpaid, but they do not automatically create a defense to an eviction action. Likewise, landlords cannot shortcut statutory procedures simply because rent is overdue. When required notices are defective or the wrong legal process is used, the court must enforce those procedural safeguards, even if the underlying dispute appears straightforward. Did you notice how often Judge Simpson explained exactly what legal element was missing before issuing a ruling? That approach gives both sides a roadmap for what the law actually requires, instead of leaving them guessing. The broader takeaway is that successful courtroom advocacy depends on preparation, proper procedure, and presenting legally relevant evidence, not simply having a sympathetic story. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.